So welcome everyone. Welcome to the Punishment and Society Digital Speaker Series. Punishment and Society is a collaborative research network, or CRN, of the Law and Society Association. Today we hear from Sameena Mulla and Hlavka discussing their recently published book, Bodies and Evidence: Race, Gender, and Science in Sexual Assault Adjudication from NYU Press. Dr. Mulla is an associate professor in the Department of Women's, Gender, and Sexuality Studies at Emory University. And Dr. Hlavka is an associate professor in the Department of Social and Cultural Sciences at Marquette University. After they speak, we will have a Q&A. You can either type your question in the chat or raise your virtual hand to ask a question live, but please do hold your questions until the end. And with that, I will hand it over to you two.
Hello, I will start. Good morning, good afternoon to everyone, wherever you are. Thank you so much, Ashley, for asking us to join you for this talk. We're really happy to be here. Before we begin, we just want to thank everyone for being here with us today and committed to spending time with us to think about the complexities of sexual violence in our cities, in our communities, in our homes. And while it is often a difficult topic to grapple with, we appreciate you joining us to consider some of the possible alternatives to our current carceral systems and why we need those alternatives. So we have come together today from many places, but Sameena and I would like to take a moment to remind ourselves of where we are and the land we occupy. So I am in Milwaukee, Wisconsin, which is the unceded territory of the traditional Potawatomi, Ho-Chunk, and Menominee, and where the people of Wisconsin's sovereign Anishinaabe, Ho-Chunk, Menominee, Oneida, and Mohican nations remain present.
And I am speaking to you from Atlanta, Georgia, which is part of the historical lands of the Muskogee and Creek Nation, who were forcibly removed from their ancestral homes through the Indian Removal Act of 1830 and violently shifted westward to Oklahoma. And I want to acknowledge, as Heather and I do, that colonialism is an ongoing process and that the law itself has been used as an instrument of displacement and dispossession. And so in the work we present today and our work moving forward, we are often attenuated to the ways in which the law continues to play such a role in the contemporary US. And now I'm going to turn it back over to Heather.
So if you could go to the next slide, please. So turning to our work on the law and the courts, our study took place in Milwaukee, the largest city in Wisconsin, the fifth largest city in the Midwestern United States, and the second most densely populated metropolitan area in the Midwest, second only to Chicago. Wisconsin has incarcerated over half the young Black men from Milwaukee County in state correctional facilities, and thousands from central city Milwaukee neighborhoods have state prison records. Milwaukee is consistently cited as being the most segregated metropolitan area in the US. And while white citizens represent 83% of Wisconsin's population, they are 52% of the prison and jail population. Black and Latinx Wisconsinites are each 6% of the overall population. Yet Latinx prisoners are 6% of our state's prison population, and 38% of the state prison population is Black. 1% of Wisconsin's population is Native, but 4% are in the prison population. The Milwaukee County courts are situated in this local landscape and history. And so into the fray, we located our ethnographic study of sexual assault adjudication with a commitment to thinking about the history and context of our local policing and punishment, sexual assault prosecution and interventions, and racial and gender inequities that are magnified through the court's daily practices. The next slide, please. For over a year and a half, beginning in 2013, we observed over 688 court hearings, including 34 full sexual assault trials. We purchased 22 complete trials and 54 sentencing hearing transcripts. Before that, we went over 2 years co-directing a court watch program and a pilot study for undergraduate students at the Marquette University, where we tracked the flow of sexual assault and domestic violence adjudication to get a preliminary sense of the courtroom setting and actors. We also conducted interviews with judges, attorneys, forensic scientists, jurors, sexual assault nurse examiners, and victim advocates. The next slide, please. The chapters of our book, Bodies and Evidence, are organized around the most typical order in which sexual assault trials unfold in the court, beginning with jury selection and ending with the defendant's testimony at trial or during sentencing hearings. Throughout, we focus on the process of sexual assault adjudication, showing how the court participates in the reproduction of rape myths and narratives that rely on racist, sexist, and classist tropes that are uniquely situated within the local landscapes and history. Part of this work focuses squarely on the role of science and forensics in rape trials, and that rather than dispelling them, DNA and expert testimony often reinforces sexual assault rape myths. Our work shows that the court is a site of risk and spectacle of violence for victims, witnesses, defendants, family, friends, and communities in Milwaukee. While these processes unfold in real time, they also exist as part of the judicial record and historical archives and subject whole communities into carceral institutions, reproducing oppression through sexual, gender, and racial inequities. We've conducted this research as a collaborative ethnographic feminist practice, leading together anthropological and sociological approaches to render a complex analysis of the courts. Part of our feminist practice means that we think intersectionally, that is focusing on various ways in which our research participants are rendered vulnerable in the world of the courts. For us, it has meant finding an ethical way to also include defendants within our research and to take seriously racial prejudice and the role it plays in sexual assault prosecution, and to question whether justice is always or ever what unfolds in the courtroom. Today, we share with you a snippet from Chapter 6, entitled The Good Father, Masculinity, Fatherhood, and Scenes of Admonishment. Next slide, please. So we begin with a quote, ladies and gentlemen of the court. The defendant is a wonderful man. I miss him and I love him. I was thinking not everything is black and white. There is gray, a color no outsider can see. I want my freedom back. I want my daddy back, end quote. These were the words that 12-year-old Ruthie's mother read to the court a sentencing hearing of her father, Isaac Miller, who pled guilty to second-degree sexual assault of a child. Ruthie was not present for the sentencing, but her mother requested permission to read from the victim impact statement she and her daughter had written. Ruthie's statement characterizes the ambivalence of fatherhood when it is the father figure who is the perpetrator of sexual assault. The victim's love for her father is the power that he uses to sexually coerce her. It is not possible to know whether the words written by Ruthie were her own or resulted from the influence of her family. The father is also, in this case, the husband. The tangled nature of family relations in these cases involves the complex emotions of the victim and her mother and other family members caught in the tensions of living with sexual assault adjudication. Ruthie's mother herself begged the court to be lenient with the quote, the love of her life, pleading that he was a good father and husband and not a monstrous criminal. This talk probes the narratives shaped by the symbolically dense cultural signifier of fatherhood. In referencing outsiders who could not understand what was truly unfolding in the family, Ruthie pointed to the secrecy and privacy that engenders sexual harm within the family, often perpetrated by a paternal figure who wields violence against both children and his partner. Silence can be related to love, coercion, and the unbearable weight of keeping the families together as a whole. We argue that the court's decision was rendered through a calculus of race-class intersections. Next slide, please. The court marks its moral typology of the father when it differentially assesses the impact of harm. While scholars have argued that adjudicated incest cases rarely receive long sentences, our research shows that cases involving the sexual assault of children by fathers and father figures receive far more variable sentences in the Milwaukee County courts. Indeed, the 3 cases that we discussed in this talk vary in punishment, from a 4-month sentence in the county jail to a 10-year sentence to a decades-long sentence to be served in the state penitentiary. We demonstrate that these variations are shaped by the way in which the courts interpret the relationship of the father to the child, the family, and to society. Within its genealogies, fatherhood holds positive ideological images within families and communities, and many men enjoy the patriarchal configurations and social privileges that accompany the appearance of morally authoritative provider. Other men variably inhabit these privileges, depending upon the boundaries of race and class, demonstrated through a host of paternalistic lessons and humiliations provided by judges to defendants and their families during sentencing hearings. One judge bemoaned the, quote, problems he perceived of the African-American community as he sentenced a defendant who conveyed his desire to fulfill his social obligations as a family to his own children. A quote from the judge: "It is a problem in Milwaukee, kids growing up without their fathers. Yes. Is that a particular problem in the African-American community in Milwaukee? Yes. I see fathers who literally don't care one iota for their child, and in some cases don't see them, don't talk to them, don't pay child support, and couldn't probably identify them. But to say you're concerned about your son growing up without a father, this is your fault," end quote. Exemplified by the judge's words, the marking of racialized and class-sensitized fatherhood is further enacted through the creation of courtroom records. We argue, therefore, that this literal marking symbolizes the court's racial surveillance of the family through the spectacle of the public hearing and the creation of legal and social archive. Court records are not merely inert archives, but are a repository of legal knowledge and social relations. Though the father no longer has the statutory right to discipline the family or sexually assault family members, paternal privilege, such as that modeled in the patriarchal pestis, goes through defense's use of such narratives. Defendants were not required to testify during their trial, nor were they compelled to speak during their sentencing. When they did, however, fatherhood often shaped their narratives of culpability or innocence. The rhetorics of fatherhood were powerfully commonplace from which to argue the relative merits or faults of the defendant. Next slide, please. Ruthie's words, "I want my daddy back," read by her mother, doubles as a victim impact statement and a plea for leniency on behalf of her father, Isaac Miller. The punishment she received contrasted heavily with that of another defendant, Tony Young, who was found guilty of first-degree sexual assault. While Miller pled guilty, Young maintained his innocence and was found guilty by a jury. A second point of contrast, the one that we as researchers interrogated with care, is the difference in racial identity of the two families involved. While Miller and his family were white, Young and his family were Black. We begin our talk with State v. Young, a trial replete with moments in which the defendant is both denigrated and lauded for his role as father, themes that were carried out through to his sentencing. We then return to the sentencing of Isaac Miller, detailing the ways in which the court, the family, and the defendant himself produced narratives of failed and successful paternity. Both cases also contain moments in which it is not simply the defendants, but the families that are addressed by the court. In the final section, we widen the scope of this talk by discussing a case in which judges directly addressed the defendant, Travis Trenton, and his family during sentencing. These admonishments aim to document the father's criminality for the court while simultaneously revealing his true nature to the children and partner seated in the gallery. These public commentaries and forms of record making are further examples of racial surveillance practices that distinctly mark Black and brown fathers and Black and brown families as intergenerationally pathological. Examining these various moments in which fatherhood is evoked sheds light on the ways in which the court reproduces white, heteropatriarchal notions of appropriate performances of masculinity and sexuality according to racialized and class notions of the welfare state. Next slide, please. So this case, we talked about negating parental care, State versus Tony Young. By the time that we observed State versus Young in November 2013, we had already observed 22 jury trials, of which many involved father figures, including biological fathers, stepfathers, mothers' boyfriends, grandfathers, and uncles. In this case, Mr. Young was charged with 3 counts of first-degree sexual contact with a person under the age of 13 and 1 count of incest with a child. The assaults came to the attention of the authorities after Young's then 15-year-old daughter, Tasha, wrote a letter to her mother explaining that she had been keeping a secret about how her father sexually assaulted her on multiple occasions between the ages of 7 and 9 on weekends when she was at her father's house. Judge Williams presided over the case. Mr. Young was in custody at the time of trial, though in lieu of his prison jumpsuit, he wore civilian clothes. For the trial, he dressed in a black suit with a crisp white button-down shirt so the jury would not know that he was imprisoned. The suit fit him well, which was not always the case. Some defendants wore borrowed gear supplied from the court or their defense attorneys. Before the jury entered the courtroom, Young's defense attorney handed him a tie to wear. The prosecutor, ADA James, called the victim Tasha as her first witness. Tasha, African-American like her father and her mother, was a youthful 16-year-old at the time. She walked slowly into the courtroom and passed through the heavy door separating the gallery from the courtroom. She wore a long-sleeved black crew neck shirt with khaki-colored jeans. She had a small tan-colored purse strung across her shoulders for the duration of her testimony. Her hands were folded lightly in her lap, and she looked directly at the ADA for most of her testimony, speaking clearly and directly into the microphone. Following some opening questions about Tasha's educational background and age, ADA James asked Tasha to explain her parental divorce and custody arrangements made. Tasha explained that they had been apart since she was 2 years old. When she visited her father, she would sleep in his bedroom because he lived in close quarters with her grandmother and great-grandmother in a duplex on Milwaukee's north side. ADA James then introduced the letter Tasha had written to her mother, labeling it Exhibit 1, and defense objected. As the attorneys argued in chambers before the judge, Tasha was left alone on the witness stand, exposed to the jury, the public seated in the gallery, her father, the defendant. She concentrated on the letter she had written, which the prosecutor had left in front of her. Her small sighs were audible as the microphone was left activated during the sidebar. A full 7 minutes passed before the judge and attorneys returned to the trial, and they continued. ADA James said, "Why did you write that letter?" Tasha said, "To tell my mom what Tony did to me. He molested me between the ages of 7 and 9. ADA James, "What is your first memory of his behavior?" "When I was in the bathroom with Tony, he was in the bathtub with his clothes off too, and he started washing me. His hand touched my vagina." The ADA said, "This happened for a few years?" "Yes." "What is the next memory you have about being molested by Tony?" Tasha said that she had no specific memory, but she remembered excessive touching every time she saw Tony overnight. In her descriptions, the conflation of care and abuse were palpable. Her recollection of paternal care, the act of being bathed, could only be articulated as excessive touching. Tasha's dawning awareness of her father's abusive acts were linked to her educational experiences at school. When the prosecutor asked how she knew the touching was excessive or wrong, Tasha responded, "Sex education. I didn't know really what a father should be, what my expectation should be. He'd put his penis in my hand." Her education was not limited to sexual knowledge about her body, but was also her ability to identify, quote, what a father should be. Tasha's further description of Tony's head on her chest and his stubble from his beard could not be mistaken for parental tenderness, but were clearly something sinister and unsettling. As she described the many acts of sexual victimization she had experienced at the hands of her father, the prosecutor commented that she seemed somewhat emotionless during her testimony. ADA James said, "You seem so matter of fact." Tasha, "Because there are just some things I can't change." "Why didn't you tell? Why did you keep the secret?" Tasha said, "I thought it was normal at first, and then I was too scared to tell because it was my dad. My mom raised me not to tell adults what I think they should do." Tasha's responses to the questions emphasized the inevitability of her past. She offered 3 additional reasons for maintaining her silence. First, she said she thought it was a normal experience, echoing her earlier sense that she did not know what a father should be. She followed this with a second reason, that she was too scared to tell because her father was the abuser. Her testimony revealed the child's submission to the authority of the parent. She then stated that she had been raised by her mother not to tell what they should do. The ADA asked, "Were you being obedient?" Tasha, "Yes, I was raised to follow directions." "When you realized this wasn't normal, why didn't you tell someone?" Tasha said, "I was afraid. I didn't think anyone would believe me because people don't think a father would molest their daughter." In the second section of testimony, the prosecutor emphasized Tasha's subordinate position as an obedient child victimized by her father, who was raised to obey. In her response, Tasha also reiterated the fear regarding the nature of her relationship with the abuser, stating, "People don't think a father would molest their daughter." Looking down towards her hands as she testified, Tasha explained that she wrote the letter to her mother because she wanted to help. Towards the end of direct examination, the prosecutor asked why she had not demanded that the abuse end. Addressing the jury with resignation, Tasha said she could not tell her dad to stop because, quote, "he's my dad." Following direct examination, defense counsel asked when exactly her mother had remarried. He questioned why Tasha didn't tell her mother about the alleged sexual abuse while it was taking place, and whether her mother had allowed her to start dating in 2010. As the defense framed it, Tasha's dating life invited more parental and paternal discipline, and Tony provided it, much to Tasha's dismay. As defense continued, he suggested that Tasha was lying about her father sexually abusing her in order to get attention to get out of chores at home. "Tasha, this letter," the defense attorney said, "there are 6 lines in this letter about molestation. That's it. The rest of the letter talks about hanging out with friends and responsibilities." In explaining the letter, Tasha testified that her mother was very ill with MS and arthritis. Her brother suffered from cerebral palsy and epilepsy, and she had to shoulder many household responsibilities. Tasha insisted that she did not mind helping around the house. Rather, she was tired and she needed emotional support, noting that she now had a psychologist. Defense counsel ended this section of cross-examination by sowing additional seeds of doubt, asking, "Didn't you call your father when you got in an argument with your stepfather? And didn't Mr. Young tell you to focus on your grades and not on the boys?" In redirect, the prosecutor pivoted from the defense's framing of Mr. Young's interactions with Tasha as one of parental discipline and care, focusing instead on how he had groomed his own daughter for sexual assault. She asked Tasha to confirm that her father showed her sexual anatomy books and pornography. The prosecutor also returned to the role of sex education in Tasha's decision to come forward. By the end of trial, we had observed 3 days of testimony by Tasha, her mother, a school friend, police officers, and a school social worker, and more objections, sidebars, and departures to the judge's chambers than in any other rape trial that we had previously observed. Young chose to remain silent at his trial. During closing arguments and perhaps reflecting on his own tone and glib demeanor during cross-examination, defense counsel insisted to the jury, quote, "I don't enjoy beating up on a teenager. I have a teenage daughter, but we have to ask questions." Here, the defense attorney positioned himself as a father, noting that his treatment of Tasha only reflected his imperative to do his job. After all the evidence was presented and arguments were made, the jury found the defendant, Mr. Young, guilty on all 5 counts, including incest with a child. About 2 months later, during Young's sentencing hearing, both attorneys again raised the trope of fatherhood to argue alternatively for harsher or more lenient sentences. This time, Young was in custody and was led into a court in his prison uniform. He entered the courtroom with his eyes to the floor. He did not make eye contact with his family members seated in the gallery. Neither Tasha nor her mother were present for the sentencing and had not submitted written victim impact statements. Judge Williams began the sentencing hearing by announcing the charges, and the ADA informed the judge that she was recommending a 30-year sentence, 20 years in custody, and 10 years of extended supervision. She reminded the judge that Tasha had been sexually assaulted in various ways from the ages of 7 to 9 years old, and the assaults had taken place when the child had placement with her father during weekends. She also informed the judge that Tasha was Young's biological daughter, offering no additional commentary on this piece of information other than her disapproving tone. The prosecutor made a note for the record that she had initially offered Young a plea of 25 years, but since revised her recommendation because they had gone to trial, forcing testify to testify and publicly detail her suffering. The prosecutor characterized Tasha as a candid and truthful on the stand, and then lamented that Tasha would always associate her first sexual encounter with being a frightened child with her own father. By including such details, the prosecutor contrasted ethical paternal care and the violent reality of paternal harm. The prosecutor further argued that he had contaminated her earliest experiences of sexual initiation and had further visited harm upon her by forcing her to testify. Defense counsel began his sentencing argument by letting the judge know that Young's family was present. He addressed Young's criminal record, which he said did not include any assaultive offenses. He explained that Young, quote, grew up in a good family with a good home. He had a mother and a father. His father died when he was young. The court could interpret this information about the death of Young's father early in his life in any number of ways, as a sign of his father's presence and involvement in Young's upbringing, or as an absence read against the deeply rooted stereotype of the pathology of the Black family in relation to the missing father. Continuing, defense repeated that Young's family were good people, telling the judge that they were all employed. Young himself was a high school graduate and a certified nursing assistant. He had cared for his grandfather who passed away 5 months after his arrest. Young had also been honorably discharged from the Army and was, quote, contributing to society, but for his offenses. He emphasized that Young was neither cold nor calculating and was just a normal guy, in quotes. And he requested a 15-year sentence, just half as long as the 30-year sentence requested by the state. Defense offered the paternal care of his family members, as well as his culturally normative masculine accomplishments, including the military service and his employment as mitigating factors. When Young's own mother spoke to the court, she said that he was a good child and now a good caregiver for the elders of the family. Tony's fiance wept while she pleaded, quote, please don't take my man away from me forever. Addressing Young directly, Judge Williams then spoke. Here, you sexually assault your own child starting at a very young age. This was horrific conduct. The child should be safe and protected. You violated that. A child should not be exposed to this kind of conduct, and you brought that down on her. I watched her testify. She was very credible. First, she thought you wouldn't do it if it was wrong. Then she thought it was her fault. Then she became fearful and couldn't disclose to anyone. The first statement was not only a description of the severity of Young's crimes, but also an indictment of his parenting. In short, Judge Williams formulated his address as the failure of Young to correctly father. He followed by noting that Young's actions had not only damaged Tasha, but also the father-daughter relationship. In quotes, he said, she no longer refers to you as father, but as donor. Judge Williams lamented, no matter what I do today, I can't give that back to her. Working systematically through the factors that he would consider in setting a punishment, Judge Williams stated that Young's crimes were deeply aggravated. The social obligations and taboos of fatherhood did not prevent Young from victimizing his own daughter. You have 4 children and you're not supporting the children and you don't know how much you are in debt. This reflects your character, he said. You have a strong family support, but you hide from them. You haven't shared with them. These factors all contributed to the 40-year sentence that Judge Williams announced at the end of the hearing, longer than both attorney recommendations. Young would spend the first 25 years of his sentence imprisoned and would then serve the final 15 years under extended supervision.
Next slide, please. This section is titled Your Obvious Sincerity, the Sentencing of Isaac Miller. The sentencing hearing is an ideal place in which to observe how the cultural rhetorics of fatherhood come up against the logics of power and sexual violence within spaces of intimacy. While attorneys offer competing narratives of the defendant as father figure, the judge crafts the dominant interpretation for the court record. The sentencing hearing is the ultimate theatrical performance in which the courts decide which fathers are to be suffered and which types of fathers are categorized as irredeemable. As public spectacles, the sentencing hearing also serves as the site of archival production, in which the courts build a corpus of decisions that set standards about fatherhood, family, and the law. In June of 2013, we observed the sentencing hearing of Isaac Miller in Judge Starr's courtroom. The defendant did not go to trial, but instead pled guilty to the second-degree sexual assault of his 12-year-old stepdaughter, Ruthie. Ruthie's words, as read by her mother, opened this talk. Facing a maximum penalty of 40 years in prison, Miller, a white middle-aged man, pled guilty, which often emerged as a point in a defendant's favor, indicating acceptance and responsibility. The court also credited the defendant with sparing the victim the labor of testifying and reserving the community's taxpayer dollars. In cases involving fathers and daughters, the plea agreement was also interpreted as paternal care in this case. And this contrasts with the case of Tony Young, where the prosecutor emphasized the harm that had come to Tasha from testifying in open court. Miller's willingness to take the plea agreement and spare his stepdaughter the trauma of taking the stand contrasted markedly with Young's continued denials or claims of innocence. Miller maintained that he had sexually assaulted Ruthie only in the haze of sleep. Deeply tired, he had not realized that it was Ruthie who lay in the bed next to him. He stated that he thought that Ruthie was her mother, and because of this had proceeded to engage in sexual touching. He did not deny the harm that had come to Ruthie from his mistake, but this narrative allowed him to claim both paternal care for his victim as well as his desire for his wife, both culturally normative masculine markers that had been misdirected under the circumstances. While the court would go on to laud Miller for taking responsibility for his crime, his narrative of having sexually assaulted his stepdaughter as a sleep-induced accident might have been interpreted as an excuse rather than an admission of guilt. His entire defense emphasized the crime as a momentary, perhaps psychological lapse, rather than suggestive of a pattern of behavior. The Millers themselves presented humbly in court, seeming a bit mussed at times. Miller's wife gazed lovingly at him as she took her seat. She explained to the court that she would read two prepared statements, the first on behalf of herself and the second on behalf of her daughter, Ruthie. Beginning with her own statement, she explained that she was convinced that the defendant had an undiagnosed mental health problem, insomnia, and perhaps even Asperger's syndrome. Reading from a small sheet of paper shaking in her hand, she called the sexual assault an accident. She said that her other children missed their father greatly, and the victim, her daughter, was mostly plagued by guilt for reporting the assault. Like Young's fiance, Miller's wife began to cry as she read from her statement, again emphasizing that the assault was an, quote, unintentional mistake brought on by sleep deprivation, end quote. Her statement ended with her declaration. I still love him, she said, and I find it in my heart to forgive him. He is undeserving of the title of molester or the scarlet letter of felon. Following the mother's own statement, she proceeded to read Ruthie's short statement with which this talk opened. Ladies and gentlemen of the court, the defendant is a wonderful man. I miss him and love him. I was thinking not everything is white and black. There is gray, a color no outsider can see. I want my freedom back. I want my daddy back. Crying again, Mrs. Miller hung her head and returned to the courtroom gallery. These statements cast the father as having failed his family, while simultaneously centering his absence as the cause of great suffering for his wife and her children, including the victim, her daughter. Judge Starr thanked Miller's wife and said she was sorry for everyone's loss. Our field notes from that day characterized her words as follows. Judge Starr's acknowledgement of this family's difficult position and grief is uttered with compassion. And that's a note directly from our field notes. And in contrast, in the previous case, Judge Williams had little to say to comfort Young's mother and fiance. The ADA then spoke, offering her summary of the defendant's actions. Isaac Miller is a person in this 12-year-old girl's life. She trusted him. Her mother trusted him. The facts are undisputed. The defendant puts his hands in her pants and touches her vagina. He doesn't seem to have been asleep, and he has a clear recollection of what happened. I understand where the family is coming from, but the victim needs to be safe as well. The prosecutor's choice to describe Miller as a, quote, person in this 12-year-old girl's life, unquote, rather than her stepfather or even her mother's husband, struck us as a peculiar one. It evacuates the relationship of its father-daughter dynamic, even as Ruthie's statement pled for the court to give her her daddy back. The prosecutor also cast doubt on the veracity of the defense's position that Miller had merely been in a deep sleep. Even as she insisted Miller was responsible, the prosecutor stated that she understood where his family was coming from in their pleas for leniency. At no point did she, like Judge Williams, imply that Miller simply hid his true self from his family. Neither the judge nor the prosecutor in Young's case made conciliatory statements regarding Young's family. While the prosecutor in State versus Miller could recommend up to 40 years imprisonment for the crime of second-degree sexual assault, she instead recommended that Judge Starr give a 9 to 12-month conditional sentence with work release privileges. The defense attorney then began his argument by telling the court that Miller was an employed homeowner with a mortgage, living with his wife and her children. Upon his arrest, his client had waived his rights and provided a full statement admitting to the incident. The incident occurred because of the, quote, many stresses in Miller's life, unquote. The defense attorney insisted that Miller had a good character and that he made a, quote, less than conscious slip. He offered a letter from Miller's employer describing him as a valued employee and pointed out his supervisor present in the gallery. The combination of facts about Miller's status as a mortgage holder and as a valued employee are other markers of successful masculinity and paternity. The defense attorney then added that many of his friends are here in the gallery. Lots of offenders have good jobs and make good money, and most people have friends who'll go to bat for them. But when an allegation like this surfaces, people, friends, especially employers will pull back, but not in this case. Miller's supervisor himself made a short statement on Miller's behalf, invoking his own status as a father by attesting such was his confidence in Miller that he would trust his own teenage daughter in Miller's care. The defense attorney finished his argument by telling Judge Starr, my client, in the correct fatherly way, loves Ruthie. He is a good candidate for probation. The act was 1 or 2 minutes out of 37 years of life. Judge Starr asked Miller if he planned to make a statement. He indicated yes as he cleared his throat and began to speak slowly and steadily. And he said, a few months ago, I did something I never thought I was capable of doing. I became the kind of person I hated. I am to blame. I promise I'll spend the rest of my life making up for it. I need to tell Ruthie I love her and I'll never hurt her again. Finished with his statement, Miller seemed the very embodiment of contrition as he wiped tears from his eyes and his wife's audible sobs filled the court. Noting Miller's tears, Judge Starr addressed the defendant and the court stating, I think the record should reflect your obvious sincerity. Without cameras in the court, such remarks by judges were the primary way that demeanor came to be part of the court record. She then continued with the rest of the sentencing, noting her disbelief that sleep deprivation could be blamed for the crime. And this is what the judge said. She said, I've been sleepy, sleep deprived. I would never touch the genitalia of a 12-year-old boy. I just don't see how it happened. A 12-year-old girl, she should be playing with Barbies. There is an obvious tension between Judge Starr's sequenced utterances here, and noting his obvious sincerity, she generated a record of Miller as a truthful person. With her next breath, however, she stated that she did not find the story credible. In short, while the court credited Miller with taking responsibility for his crime, he in fact did not admit to having intentionally sexually assaulted his daughter. Moving on, Judge Starr said she was happy that the victim finally disclosed the sexual assault, explaining to Miller that his, quote, behavior needs to be checked. Once you cross the line, it's easy to keep crossing. Sexualizing young girls at younger and younger ages. Ruthie needs to know the guilt flows from your actions. No one should feel guilty for being honest. Probation is very generous in this case. I take into account the unwavering support of your friends and employers. Despite her admonishment and the seriousness of the offense, Judge Starr imposed and stayed a 4-year sentence of 2 years in custody and 2 years under supervision for full 4 years of supervision. A stay is a suspension of the sentence if the defendant adheres to all conditions of supervision. Judge Dar then ordered the defendant to serve 4 months in custody with permission for work release as conditioned time. The judge ordered no contact between the defendant and Ruthie and told Ruthie's mother that she would need to petition the court if she wanted to change these conditions in the future. The statement to Ruthie's mother was the only point at which she directly addressed Miller's family. Next slide, please. State versus Trenton, fathers and daughters at scenes of admonishment. The contrasting forms of address between the cases of Miller and Young illustrates the range of admonishments that judges may choose to direct. In this last section of the talk, we describe one more case in which a judge directly addressed the defendant and his family. This form of disciplining, as we've noted, is both an admonishment that unfolds in the present of courtroom proceedings and an utterance permanently preserved in the court record. Our own field notes are replete with scenes of admonishment in which judges speak on the record and dress down the defendant and his family. Thus, both the courtroom practice and future transcripts reproduce official narratives of the failures of the father, characterized by penal logics unfolding at the intersections of race and class. As a racializing practice, Black and Latinx fathers are faulted for their perpetration of paternal harm, and that paternal harm is interpreted as socially learned and socially transmissible. The extent to which the judge casts the paternal failure as influencing the family and harming the wider community is revealed in the formal admonishments they make on the record. When paternal harm is indexed as jeopardizing social welfare beyond the family, it is more harshly punished. We discuss here the sentencing of Travis Trenton before his family. Travis Trenton was charged with 2 counts of possession of child pornography. His case was one of the few in which the judge sharply rebuked a white defendant and his white family. Trenton pled guilty and faced a mandatory minimum 5-year sentence for each count, as required by Wisconsin statutes. At the time, no other sex offenses carried a minimum sentence. The images that had been found on Trenton's computer were of children he did not know. His daughter and girlfriend were both in the gallery to support him during sentencing, and his daughter began the sentencing hearing by saying, "He's a good father. He's a hard worker. We always had family time. We were always close. He isn't a danger to children. He's never done anything to me or my friends. I hope you give my dad the minimum sentence." His girlfriend was tearful as Trenton's daughter spoke, and then added her own testimony. She explained that Trenton had changed her life and noted that he's trying so hard. They were to be married, and she was convinced that he would never harm a child. That's not who he is. Please have mercy and give us the chance to heal together. Her statement complete, it was Trenton's own turn to make a statement. Looking down slightly, Trenton spoke on his own behalf, and he said, "I apologize to family and friends for the embarrassment I've caused them." His daughter began to cry as he expressed his commitment to building a relationship with his family. "I want to be remembered as a good person. I apologize to counsel and court staff." In response, the judge pointed to Trenton's daughter and stated, "You have embarrassed and disgraced her. She needs to know what you were looking at, so I'll read some of these." The judge then proceeded to read some of the descriptions labeling the images that had been found on Trenton's computer, detailing the ages, positions, and sex acts in 9 of the many photos he had to view during the case. In detailing the content of the images in the presence of Trenton's daughter, the judge himself contributed to the experience of embarrassment, disgrace, and disgust for which he had just earlier condemned Trenton. What's more, the judge, speaking for the court, gave vivid descriptions of the images of child pornography in a tone both crass and detailed. Here a penis and there a vagina, both positioned just so, rather than forego the descriptions altogether or approach their contents in a clinical fashion. The judge reproduced the pornographic essence of the archive of images that had led to Trenton's arrest and conviction. In short, to justify the harshness of the minimum sentence, the judge subjected those present in the court to pornographic descriptions and perpetuated at least their verbal circulation. The judge remarked, "I generally don't like mandatory minimums, but legislation got it right this time." He continued to berate Trenton, saying that because he was, quote, "downloading sick images," the aggregation of child pornography on his computer was not some mistake. The judge added, you have some sort of perversion. Then addressing all those in the court once more, the judge continued, he's clearly overly sexualized, noting that the pre-sentencing investigation reported that Trenton had about 100 sexual partners and had attended swinging parties, nudist beaches, and admitted to watching pornographic films. I hope your daughter and significant other understand you have issues. How would you feel if this happened to your daughter and not these images that are out there? Before delivering the full sentence, 5 years on each count to be structured with 6 years in prison and 4 years under supervision, the judge continued to address Trenton's daughter and girlfriend, dragging the entire family into Trenton's humiliation and punishment. By asking Trenton how he would feel if his own daughter were to be a victim of child pornographers, he threatened Trenton and objectified the young woman accompanying her father to court. Next slide, please. The cases discussed in this talk demonstrate not only the court's logic of sentencing and the de facto modes of surveillance and marking of racialized fatherhood that occurs in concert with the sentencing, but also the range of discretionary decisions available to a felony courtroom judge. The charges of second-degree sexual assault faced by Miller can carry a maximum of 40 years of imprisonment. Miller received considerably less than that. Twice, we saw defendants sentenced to 35 years in relation to charges of second-degree sexual assault. Trenton's case required a mandatory sentence because of the legislation governing child pornography in Wisconsin. The judge, having little recourse, thus crowed his outrage. Beyond the few crimes that carry mandatory minimum sentences, judges can exercise a wide range of discretion in sentencing convicted sex offenders. While we did not discuss this stage in this talk, the prosecutors also exercise discretion when they decide which crimes to charge. The charges are a scaffolding for weighing the gravity of the sexual offense committed by each defendant, and Young's crimes carried a heavier sentence. And while prosecutors rarely raise the issue during interviews, they did acknowledge how case outcomes might be determined by race and class differences. In the courts, the cultural signifier of fatherhood is narrated through tropes of masculinity, sexual power, virility, and aggression. It is the judge's decision whether to frame these tropes as appropriate and normative or abnormal and criminal. In Miller's case, the judge stressed the possibilities of his care and responsibility, where other fathers were cast as irredeemable, whose violence has exceeded the boundaries of the family. The court may interpret the role of the father as socially fundamental, as familial obligation, as state compulsion, and as personal failure. The criminal courts are the site of daily ceremonies of what Nicole Gonzalez Van Cleve has called racial degradation. And the attendant social commentary that emerges on the state of fatherhood is mired in racialized and racist narratives that are also inflected by class. Judges and attorneys engage with problematic artifacts of outdated social policy that pathologize the Black family by citing absent or derelict Black fathers, or commenting on the disciplinary machismo of Catholic Latino patriarchs, which occurred in other cases that we saw. White fatherhood did not emerge as a social phenomenon. When we witnessed the admonishment of white fathers for their crimes, they were most often chastised as individual bad actors, with few queries about their ties to community or the negative social influences that brought about their criminality. For men of color, racialized narratives are reproduced by evoking the welfare state, public safety, and normative heteropatriarchal families. Such cultural narratives attach squarely and successfully to men of color in an urban courthouse embodied by patterns of segregation, mass incarceration, disproportionate poverty and joblessness in communities of color. But even as the father figure is capable of the most abhorrent acts seen in the courts, he simultaneously holds the potential to be cast as the most morally redeemable subject worthy of the court's leniency. In naming fatherhood as one of its central concerns, the criminal justice system both engages with and reproduces the gendered and racialized conditions that create the vulnerability that results in sexual victimization in the first place. Thank you very much.
Fantastic job. So everyone, please join me with a virtual applause. Wonderful. Definitely some difficult, oh, sorry, there, my camera is on now. Very difficult subject matter to grapple with. So now we have time for a Q&A. So if you have a question, please go ahead and either raise your virtual hand or you can put your name in the chat box, or you can put your question in the chat box if you don't want to go ahead and ask your question audibly. And while people are gathering their thoughts, I'm going to go ahead and take my organizer's privilege and throw out a comment and a question. The comment sort of could lead into a question. You can decide if you want to engage with it or not. So during your talk, I was thinking about focal concerns theory from sentencing disparities studies, and the way in which, so like my understanding of focal concerns is basically judges look to judges and arguably juries, but mostly judges basically look to the kind of fit of stereotype, and so they tend to be kind of racialized and crime kind of combination. So if a Latino person and a drug crime, a Black person and a drug crime, a Black person and a violent crime, for example. So they have these kind of like stereotypes of who is involved in what type of crimes. And then if they do that type of crime, if the person in front of them kind of matches both of those boxes, then they get a more serious a penalty than if it's a Black person doing a white collar crime or something that is under these stereotypes unexpected. And I was thinking about like I'm pretty sure focal concerns doesn't talk about fatherhood, but like in a sense that's also what you're doing here is you're talking about stereotype fit, where there's this trope of the bad father and how that's racialized and classed. But like that's not something that you're going to see in quantitative data. Like they don't code mentions of fatherhood in data sets you get for sentencing disparity studies, and that's super interesting. But it's also, it kind of seems like it's not necessarily something you can predict ahead of time because it's constructed. It's something that has to be kind of argued in the course of the case. And so like if you're to try to do this as a quantitative study, it seems like that would be really tricky to do. So that's kind of just something that was floating around in my mind, is like this not only illustrates the wonderful contribution of qualitative methods, but it's also a nice kind of contribution to and almost challenge to focal concerns theory. My actual question is just kind of a small one. So all of your three cases involve fathers assaulting and molesting their children. I was wondering if you see the fatherhood trope come up in other cases of sexual assault, especially like, in movies, for example, you often see like the father of a rape victim. It's like, oh, I feel so bad for the father because, how must he feel? And it's, I feel bad for the rape victim, not, the father. But I'm wondering if that comes up at all in these other cases. So if you see fatherhood, that's just one example, but if you see fatherhood coming up in other cases and what that looks like.
Heather, do you want me to start and then you'll jump in, or do you want to lead with this one? Okay, you're nodding. Thank you so much for the comment about focal concern theories. I would probably love to hear more about where you see them challenging, the fatherhood trope, because I think one reading of it would be that it actually like might fit quite neatly into those set of models, but that might be a conversation for a different day. One of the things that Heather and I found so fascinating about sentencing, and it's not detailed in the talk today, is there are obviously many different metrics that are also being invoked at the point of the sentencing hearing, and we counted at one point like 11 distinctive instruments that are various risk assessment tools. None of which are actually calibrated to speak to one another, which we also find really interesting. So, I mean, like there are many studies challenging a single tool or a particular tool. Wisconsin is probably using all of the tools, and they're also using them in a way where they're being used in order to really hold up a certain kind of discretion. And the set of kind of proxy variables for race in a number of those metrics, like things related to whether your parents have criminal records, whether you've been exposed to crime, which, just given that early slide that we showed people from the prison policy forum, right? The likelihood of having a criminal record in the city of Milwaukee is absolutely predictable in relationship to race, right, and gender. And stepping back, looking at the sentencing disparity studies that have been done in Milwaukee, what I understand is the sort of two factors that intersect and predict the harshest sentences are race and gender, actually, and age. So it's young Black men who are most likely to receive the most punitive sentences, and the research that was done along these lines looks at a range of felony crimes and does a lot of matching to the extent that they can between similarly situated people who have been sentenced to the same felony crime. And that's sort of ongoing work. And it's so important for us as ethnographers to understand that this is the context in which we are in the courts and we are watching. And so we were really trying to weigh heavily what we knew the patterns were in order to understand how it is that we're getting there, right? Like precisely for the reasons that you point out, Ashley, that these aren't things that can be enumerated. And so maybe I'll pause there with the first part of your question. And Heather, do you want to speak on the question of fatherhood beyond father-daughter cases?
Sure, thanks. Thinking about it, I was struggling in my mind to actually remember a case or a sentencing hearing where it wasn't brought up in some way. So the answer is definitely yeah. I mean, these tropes of fatherhood as they were racialized and class were replete in the hearings and sentencings that we observed and heard about. I distinctly remember, a judge often calling out on young Black men who may have been in the courts for a variety of reasons, right? Actually, we did sit in the felony courts, which include a lot of different criminal cases. So homicides or assault, domestic violence, and always really talking about, in his particular way of framing it, well, you probably didn't have a father in your life, right? Or, big surprise, you probably didn't have a father in your life and he wasn't there to help you. Well, if I was your father, I would have done this, this, and this, right? And you wouldn't have ended up in court. So even when the defendant was not himself a father, this narrative was, all over the sentencing hearings, the preliminary hearings. And that was very, very distinct between, very clear about Black and Brown communities in Milwaukee versus white communities. There was a couple cases I recall that the father of the victim was in court during a sentencing hearing. That was with the mother's boyfriend that may have done a sexual assault. And the judges always referred to the father sitting in the gallery as well. Right? Like the pain that he must be going through, the pain of the family, to be supporting his family and then have this other man come into the family and do this. So yeah, it was everywhere.
Fantastic. Thank you. That's so interesting. So other questions from the audience? Chris, please go for it.
Yeah, thanks so much. It's been fascinating to see where this research has gone. It's terrific. And I was curious about, I'm going to put a case in the chat. I'm guessing you're probably familiar with some aspect of it, but there's a challenge to Wisconsin civil commitment law. Basically, that there's an anti-urban bias because you've got to go live in your home county, as I understand it, and there's no housing available for people convicted of sex crimes in Milwaukee. And I'm wondering, it made me think about how fatherhood is implicated in the decision to civilly commit, or the good father, or et cetera. So just if you have any thoughts on that, it'd be interesting.
Go for it, Heather. No. This is an aside. Before I left Wisconsin, in a different time, I got into a huge debate with a alderman running for re-election who was knocking door to door, who was so very proud of the punitive policies that had been adopted in the county. I mean, he was quite a character. Knocked on the door and asked me, like, well, what do you care about? And I was like, inequality, affordable housing, good public schools. And he was like, but, here's this great set of policies that I've recently passed to keep us safe from sex offenders. And I said, that's not going to work with me because I know what the threat actually is. And I don't believe in cruel and unusual punishment. And I actually think we're cruising to get sued. And I actually hope the county does get sued. We ended the conversation with him telling me that I should be cautious about, how big tobacco fabricated research. And so I told him, Mr. Zielinski, there's no such thing as big sex offender. And that's kind of where we left it. So the kind of electoral politics and legislative politics and regulatory politics around sex offenses, I think, are oftentimes where the rubber meets the road for people who have abolitionist politics, including for Heather and myself, right? And Milwaukee is a really interesting place because it's seen as this kind of progressive, densely populated progressive political space in the state of Wisconsin, right? It has a storied socialist history, in fact. And people are quite proud of it, right? They had the longest seated mayor who was elected from the Socialist Party. Everything's named after him. And so within that space, it's very interesting to see people who are very proud of their progressive politics actually pass very regressive laws. And sometimes, I mean, it's very interesting for me to see where this goes, in terms of challenging commitment laws, because right now Wisconsin is in a point where there's, I would say, a kind of a panic taking place, right? Post Waukesha, if we think of the Waukesha Christmas parade, which was a very tragic incident, right? So simultaneously to the challenges over the commitment laws, there's actually movement to increase cash bail, right? Wisconsin is one of the only states that does cash bail, and we're talking about increasing it. And we all know how racially regressive cash bail is. So that's happening right now. And even without those reforms in place, we're actually hearing in the courts now that commissioners are denying bail requests, right? So those changes are already happening. And we are also seeing a lot of panic around, this is, going to seem like a really small one, but reckless driving. There have been a number of high profile reckless driving cases, right? And this again ties back into Waukesha. And so there's a new standard operating procedure that's been approved in the city of Milwaukee, where if you are a second offender for reckless driving, your car is immediately impounded, which is, really a very extreme measure. And again, very racially regressive, like we know who's going to be targeted. And the state politics are such that there's a kind of, real tension between the rural and the urban, and what happens in one place becomes the logic for the happening in another place. And of course, people talk about it as rural and urban, and these are all dog whistles for whiteness and blackness as well. Because we imagine, at least, that rural Wisconsin is primarily white. So that's my sort of anthropologist holistic response to, what all of these. I don't think you can just look at one policy and one set of legislations, because all of this is unfolding at a really charged landscape where there are other legal and statutory moves that are afoot.
Thanks much. Yeah.
Great. Other questions? If we don't have other questions, I might go ahead and turn off the camera, and then people who maybe are deterred can ask a question after that. But I now see a question from Michelle. Go for it.
Yeah, I can ask a couple of questions, although I like the turning off the camera strategy.
Do you want me to
That's
go ahead
smart.
and do that, or?
I don't have a strong preference, no, but I was waiting to see if anybody else was going to jump in with questions, and if any grad students were going to ask questions before I did. So maybe that will encourage people too, but we've got time. So I had a couple of different questions. I thought maybe I'd just sort of throw them all out there and you guys can think about them or talk about them to the extent that that's interesting to you. I was wondering about sort of your commitment to a feminist methodology, and it sounds like a moment ago too, sort of an abolitionist praxis. And I wondered how you thought about that in terms of writing up the results, and in particular, a couple of things. So one was, I've done similar like big sort of qualitative studies with big teams. And one of the things I've wrestled with is like how to think about what authorship means in the context of those. So like sort of how you thought about like sort of the different publications and products coming out of it, and how you brought on different collaborators on those different pieces. And also whether there were sort of community groups that were involved, particularly on the like court watching piece, and how you thought about the relationship between the academic work and the work that they were doing in the community and the court. But also in terms of, when you do court watching, you collect so much data, right, that it is impossible to talk about it in all of the findings. So thinking about how did you think about methodologically sort of which cases to highlight as you were writing it up, and how did you think about that in terms of like, how do we represent all of this data that we've gathered, and do it in such a way that we're sort of empirically rigorous and thoughtful, and also trying to make the kinds of arguments that you want to make with the book. And then did you struggle at all with sort of thinking about, what potential re-trauma or harm could come to the people who were part of the court cases that you were trying? Particularly, I was thinking like whenever you described a victim's like clothing, I appreciated the ethnographic detail, but part of me also was like, to be that person sitting on that stand, right? And then to like potentially come across this writing. And of course, these cases or these trials are in theory sort of public spaces, but how do we think about too, like sort of writing about these racialized degradation ceremonies, right? And what that means around sort of the ethics of how we talk about the cases and what lengths we do or do not go to anonymize people. The sort of standard logics of consent don't really make sense when it's a public space, but it's also sort of a semi-private space where you're not there sort of recording it ethnographically. So how do you think about the ethics, particularly in this feminist framework? And then my other question, which is a really big one, so feel free to just punt on it, but at the very end, you said that the way that the courts reproduce these racialized, class gendered scripts then sort of further reproduces the same violence that produces the assaults in the first place. And I wonder if you could say more about sort of how in the book you conceptualize the origins and explanations for why this kind of crime happens, and how you sort of link those two processes. Obviously, that's somewhat outside of your data, but understanding sort of your own perspective on sort of like what kind of phenomenon this is then shapes how you sort of talk about it as it enters the court process. So I don't know if any of that's helpful. That's a lot of different stuff, but that's the kind of stuff I was thinking about, and really appreciate hearing about the book. I'm excited to buy it.
So maybe I'll start here. Thank you very much for all those questions and comments, Michelle. And of course, I'll hearken to Amber Joy, who is here on the call, that she was with us during a lot of this work, and she is a collaborator with us, and we've written together and published together. And so, a lot, we talk about this feminist ethnography, and a lot of work and reflection, thinking about what that meant for us as a team, as researchers, as our kind of mixed methodology and mixed disciplinary perspectives. Sameena and I, this was certainly, gosh, I don't even want to say the years, but over a decade of work together. And we brought on additional undergraduate students from Marquette as well during our time. And part of that was really thinking through, so for example, we don't want to, in our case, Sameena and I always talk about, we didn't want to have undergraduate students working with us that weren't paid. We thought it was really important for them to get paid for their time. This isn't, a graduate student experience that they're getting a publication perhaps, or, and although a number of our undergrads go on to MA, they didn't, they wanted to do it, but they didn't really need it. So finding a way to pay our undergraduate research assistants was really important to us. We did a lot of time thinking about and reflecting on the sensitive subject matter. We did a lot of training. We did a lot of debriefing, reflection, talking. We always had a collaborative space where we could come together at lunchtime because the courts kind of broke for lunch, right? Nothing was going on. And so we were also forced to come together and talk and debrief and see how everyone was doing, see how everyone was feeling, and help each other out. We knew that, if someone couldn't be sitting in a courtroom, that we could text each other and say, something like, I have to get out of here. Can someone else come in? Or just nobody else needed to be there. It was really important for us to put ourselves and our emotions right first and foremost there as well. And certainly our research assistants. We also thought a lot about how to write this work. So this was a very, very long time of writing this book because the subject matter, and also it's very important to us, and thinking about how to write up this kind of material. So, and not to sensationalize it, right? And also not to sanitize what was happening in the courts either. And that's a really tricky balance. So I think that we spent a really long time thinking through that, thinking through how we were going to describe people in the courtroom. It is public, but for instance, a lot of scholars would say, well, you don't have to anonymize the defendant's name, right? It's all public record. You can find this all on CCAP in Wisconsin. And it was really important to us to certainly use pseudonyms for that, for a variety of reasons, ethically for us, but also because sexual violence is relationship violence, right? And family violence and interpersonal violence, intimate violence, and where many, many people knew each other. So in the cases that we talked about today, certainly you might be able to identify the victim based on the defendant's last name. So we certainly thought through some of those issues as well. And publications, thinking about who's going to be, who really took the lead on the papers, who collected the information. We all collected the information, but who really took leads on writing some of this up. Always thinking about, I feel weird, it's Amber's here, thinking about like the work that Amber Joy put into this and the research that came out of it and the publications that came out of that. And keeping our collaborations and our discussions, to this date together. And sometimes me and I will say, going back into this information or reading, and again, it's almost more, traumatizing maybe than when we were in the space collecting it actively. I think that's part of thinking through and being reflective of that information. And thinking about it as years have passed. Sameena, do you want to add to that?
I would say most of the same things. I would, getting to the specific point of the description, that was a really hard decision to us, how descriptive to be. And clearly we don't describe anybody's height or face or hair texture, hairstyle. And for me, the point of whether someone recognizes themselves in a text is actually, it's very important that it's not ambiguous. That I think about the potential harm of someone reading that text and saying, is that me? I don't think that there's a perfect solution, actually. But the ability for people to recognize themselves actually gives them a conduit to hold Heather and I responsible for the way they've been represented in that text. And we can tell you that there's a lot that is not in the book, and that we will likely never publish. We were in court and someone put a 4-year-old child on the stand. And there's no way, I think, that we can, even though it was a public, open courtroom at the time, that one was very clear for us that does not go into any published material. So there are boundaries for us as well. There are cases where there were news cameras in the room, and they were very, very public and written about. And the only ones that we included in the book were where police officers were being prosecuted. Because, even thinking about how publicly one is able to identify people, those are the ones that are not anonymized. But these are really hard questions, and I think feminist ethics are about continually trying to hold each other accountable in a kind of community of accountability that is absolutely rooted in our abolitionist politics. And I think to ask these kinds of questions as an anthropologist in the US, right, is also part of my decolonial framework, right? Because these are typically the types of questions around custom, what are the customs of the land? What are the conventions around kinship that we don't typically ask in the US, right? Because they're so taken for granted as rational and normalized. So that was part of our framework as well. And with actually, I don't think, for me, it's not a big question. Maybe it ends sounding quite grandiose, but this question about how what happens in the courts reproduces the same structures that actually create the conditions for these crimes to take place, right? Because the nature of what happens in courtroom proceedings is really deeply invested in cultural norms, it does not challenge patriarchy. It doesn't challenge paternal control. It does not challenge the right of the father, in fact, right? It entrenches it, and it entrenches it along racialized lines. So when we say that, what we're really saying is that the reason sexual violence happens is because of the way gendered vulnerabilities within intimate spaces and communities, right, are proliferated by patriarchal rights. And we're not used to being precise about patriarchy. It tends to be a fuzzy term, but I love things like Imani Gandhi's Vexy thing, where she goes back in and she's like, let's talk about patriarchy and its contemporary and specific forms and its historical forms. And so, it might not be a very fashionable thing to say that, what type of crime is this? It's a crime that has to do with patriarchal access and rights. And until our criminal justice system is something other than what it is, right? It's actually invested in those same patriarchal rights and the right to harm. I mean, it is invoking, we would suggest, right, these older genealogies of the right of the father. And so when the father is being disciplined, right, it's not because fatherhood itself is being challenged, but it's actually being invoked as a kind of cultural touchstone, right, that the outrage is that the violence of the father has now exceeded the bounds of the family, and it's become a public problem. So that's what we mean with that vague provocation at the end of this talk. Thanks so much, Michelle.
Okay, so we still have, oh, I'm sorry, go ahead.
I was just going to add one more thing because I forgot to address Michelle's question about case selection. And I do think it's really important to think about. I mean, The way we did that was through, really thinking about what patterns are coming up, what was deeply representative. In the ethnography, of course, we want to really talk about that deep description in the process. And so as we went in and kind of outlined this book and went through our notes and everything and analyzed this data, we picked out the cases that were most representative of the patterns that were clearly evident, and really showed some of those, juxtapositions between, in this case, the sentencings. But they were really, really common, right? So, I can think of, 20, 30 cases just off the top of my head that are deeply the same as Tony Young, right? Or Trenton, as we use the pseudonym. I'll also add that I really think that feminist research and ethnography is deeply about sharing and our friendship that we've cultivated over decades, but also being able to conflict and challenge each other and know this is important for me because it is often like you actually, for a co-authored book, you think, oh, half the work, right? And yeah, right. Absolutely not. I mean, it was probably like 20 times the work that anything else I've ever done on my own. And I hope it's 20,000 times, I know it's 20,000 times better analytically because we, were able to discuss different analyses that we had from different disciplinary perspectives from, and that really made the work truly grounded in our data and truly, poured over for years and years and years. So I'm much more confident in a lot of those analyses. And then I'll just add real quickly that, Sameena ended with talking about the vulnerabilities that the courts create. I mean, the court is actually also creating harm and violence in that space and vulnerabilities that it purports to punish or, heal, or that there's justice being done in that space, right? And, that's not what we saw. We would vehemently argue that the courts are creating violence within the family. They're breaking up families. They're mass incarcerating, community members. They are putting many people in more harm's way, right? So, many women, mothers are left to say, in many cases, well, what am I going to do now? I have no money. He was the breadwinner. And those are really important things for us to consider as we think about how justice is being meted out in the courts, or what it's purported to do, and how the courts are literally creating more vulnerability for many families and children, right? Oh, that's it. Thank you.
Wonderful. Such an important topic. So we are basically out of time at this point. So if everyone can join me with another virtual round of applause for a really fascinating and important talk. Congratulations to you both on your book. This is really fantastic. So with that, I'm going to go ahead and turn off the recording. Where's the recording? It's disappeared. Sorry, hold on.